If you're watching this, you're probably feeling an anxiety that's just overwhelming. The fear that your child might be in immediate danger is one of the worst feelings a parent can have. So today, we're going to talk about a really powerful legal tool you have in Illinois, the emergency custody order.
That's the core question, isn't it? It's that pit in your stomach, that fear that something terrible could happen. When that fear becomes real, knowing what you can do is absolutely the most important first step. So let's dive into how you can take action.
The good news is you're not helpless here. The legal system actually has a tool specifically for these kinds of crises. It's built for speed, designed to protect the child right now. So let's break down what it is and, more importantly, how it works.
So, what exactly is an emergency custody order? Well, the best way to think of it is as an immediate legal shield for your child. It's something a court can put in place when you truly believe that harm is just around the corner.
Here's the textbook definition, but let's make it simple. Under Illinois law, a judge can grant this order incredibly quickly. And here's the key part. Sometimes they can do it without even hearing from the other parent first. The whole point is to stop what the law calls immediate and irreparable harm before it happens.
Okay, a quick but really important heads up on the legal jargon. You and I, we say custody. But in an Illinois courtroom, you're going to hear this phrase, allocation of parental responsibilities. It means the exact same thing. Who makes decisions, who has parenting time. So don't let the formal language throw you off.
All right, this next part is absolutely crucial. Giving a judge the power to change a child's living situation in a matter of hours is a huge deal. It directly impacts the other parent's rights. Because of that, the standard of proof, what you have to show the judge, is incredibly high.
This chart really draws a bright line in the sand. On the left, you see the kinds of things a court sees as a true emergency. Real physical danger, substance abuse that puts a kid at risk, serious neglect, or the threat that the other parent might take the child and disappear. But look at the right side. These are things that, while maybe frustrating for a parent, are not legal emergencies. Disagreeing on parenting styles, not liking a new boyfriend or girlfriend, those just don't meet the high bar. The court needs facts, not feelings.
And this quote pretty much says it all. You have to walk in with concrete, solid evidence. A judge simply cannot act based on what you think might happen or what you're afraid of. They need proof of a clear and present danger to that child right now.
So let's say you believe you meet that high bar. You have the grounds and you think you have the proof. What do you actually do? Well, let's walk through the practical, step-by-step process of filing. Think of this as your roadmap. It all starts with preparing a petition. That's the legal document where you lay out the facts. At the same time, you're gathering all your evidence. Then you file it all with the court and ask for that emergency hearing. Once you have that initial hearing, your job immediately shifts to getting ready for the big follow-up hearing. So what kind of evidence are we talking about? We're talking about real, tangible stuff. Things like police reports, if they've been called, medical records, if there's been an injury, photos that show the danger, even text messages, emails, or sworn statements from people who have witnessed what's going on. Each piece helps build your case. I really want to stress this part. This speed here is no joke. Because it's an emergency, you could literally find yourself in front of a judge on the very same day you file your paperwork, sometimes just hours later. And that's exactly why you have to have all your evidence, all your ducks in a row before you walk into that courthouse. Okay, let's imagine the best case scenario. The judge has listened to you and granted the emergency order. You can finally breathe a little. But it's so important to understand that this is the beginning of the next phase, not the end of the story. This number you see here, this is key. An emergency order is not permanent. It's a temporary fix, a band-aid, that usually only lasts about 10 to 14 days. Its only job is to keep your child safe until everyone can come back to court for a full hearing. So here's how that timeline usually plays out. Day 1. The order is issued. For the next 2 weeks or so, that protection is in place. And within that window, the court schedules a full hearing where both parents get to be there. It's at that hearing that a judge will make a more lasting decision based on everything they hear. And that follow-up hearing is all about fairness. See, the first order was granted based on just your side of the story, to make sure the child was safe immediately. This next hearing is where the other parent gets their full day in court. Both of you can present evidence, bring witnesses, and make your case before the judge decides on the next steps. Okay, we have covered a ton of ground, from the legal definitions to the step-by-step court process. So let's boil it all down to the absolute most important things you need to walk away with. If you remember nothing else,
Please remember this checklist. 1. These orders are for immediate harm only. 2. You need strong, specific proof, not just a gut feeling. 3. It is a temporary solution, a bridge to get to the next step, not the final destination. 4. A follow-up hearing where both sides are heard is guaranteed. And finally, number 5, while you can do it yourself, getting help from a lawyer who knows this process is really, really recommended.
And that brings us right back to the beginning, to the most important question of all. But now you have a much clearer picture of what the process looks like, what the court requires, and what happens next. Now you're better equipped to decide if filing for an emergency order is truly the right first step to protect your family.